Good morning, I'm Marcus Michles, and I'm joined today with John Rogers. This is the Michles Booth video blog, and we've got something to celebrate. It's good news, at least if you're a fan of the jury verdict system and sort of the jury system in general. Wouldn't you agree, John?
Absolutely. It's a great day for Florida lawyers and Florida residents, especially people that might be trying to use the system for the medical malpractice claim process.
And what we're talking about is the Florida Supreme Court ruled on, I think it was June the 8th, just this month, that the medical malpractice caps on non-economic damages are unconstitutional, that they violate the Equal Protection Clause of the state statute, the state constitution. And so a long battle that I can tell you that I was on the front lines of and the losing side of that fight over 10 years ago, the Florida Supreme Court has decided that there is no cap, no justifiable cap for damages in a medical malpractice case. What do you think about that, John?
Well, I think it's good news. I think that if you asked many practitioners over the past 3 or 4 years, since McCall has come down, we've been waiting for the next foot to drop. A decision about 3 years ago, plaintiff's name was McCall, was decided that kind of got halfway there. Caps were struck down for wrongful death cases only. So there's been some uncertainty in the law, and I think the Supreme Court finished what they started with McCall earlier this month, and it'd be hard to say it wasn't something that we could kind of see coming.
Yeah, and if you think about caps philosophically, I mean, I'm a trial lawyer, John's a trial lawyer, we have strong opinions about this, but by and large, we trust the jury's decision. And if a jury decides that that the fair measure of damages is, for example, $1 million or $2 million, then so be it. For example, in a comparison case, if you get hit by a drunk driver and the measure of the damages that you sustain in the jury's opinion is $2 million, the drunk driver, or more appropriately their insurance company, is responsible for $2 million. In the medical malpractice world, which is an entirely different world in a lot of ways, that same measure of damages, for example, a jury awards $2 million, is reduced to $500,000 or $750,000 without getting into the statute too deeply. It's reduced arbitrarily by the finding of the Supreme Court, arbitrarily in my opinion, arbitrarily in most trial lawyers' opinions. The jury verdict should stand as the correct measure of damages.
Absolutely. I think one thing that's a little confusing about the holding and something that I struggle to explain to new clients is the concept of non-economic damages itself. Because all damages are economic in nature, and what the court means when they say non-economic damages are things that are intangible, things that are meant to compensate you for your pain and suffering.
That's where it boils down. To the layperson, it's the pain and suffering line on the verdict form, right?
Absolutely, yes.
Yeah. So the caps don't cap economic damages, wage loss, medical bills, past and future, but they cap the intangible damages such as pain and suffering. And that's something that's intimately measured, very difficult to predict, very difficult to calculate, and that's where the jury comes in. But let me take us all the way back to 2003 when this cap business first started and when the Florida Medical Association got it passed. They got it passed by arguing that there was a med mal crisis in Florida. I'm going to tell you what, I was standing in the Senate on the floor making an argument then, it's still true today. There was never a medical malpractice crisis in Florida. There never was. It was a fiction then, it's a fiction now, and it took the Supreme Court about 10 years to sort it out and say, you know what, that's just not true. The argument was doctors were fleeing the state in droves. They were going to some state where they weren't responsible for their malpractice. I called it jokingly the state of utopia. There was no state in America that existed where you could go to and not be sued or be held accountable for your mistakes. But the argument was this crisis was driving them out of the state, and that premiums were going up, and premiums were making it impossible for doctors to get insurance. None of that was true. Empirically, it was defeated 10 years ago. It wasn't true in 2003 or 2009 or 2011. It's not true today. I'm getting a little bit high-strung about that, John, but you're aware of this argument. You've seen it before. Empirically, it just couldn't be borne out statistically. The insurers in Florida have had a boom because they sell insurance and they don't have to pay back the full measure of damages like they do in many other states. Meanwhile, in the last 15 years, the number of medical malpractice insurers who are licensed to do business in Florida has tripled. If you ask any doctor out there whether their premiums have gone down, they'll resoundingly say no, they haven't. So the doctors aren't going anywhere. They love living in Florida like we all do. There's more coming every day. There's no loss of specialties or specialists coming out of school. That was one of the arguments that was made, was that the neurosurgeons and the obstetricians and the thoracic surgeons were going to go do their high-risk business elsewhere. That turned out not to be true. It was all just a fantasy. It was all just a myth. It was a unicorn all along. What do you think?
I think that's right, and I think one of the remarkable things about this decision is that the court bases their finding on an equal protection analysis. And so they say there's no rational basis whatsoever for the law. They essentially say that all of the reasons that were argued back in 2003, they've not been borne out, either in reality or with studies or otherwise. And so for the court to go that far to say there's no rational basis is a pretty rare finding.
Yeah, it was strong language, and I thought it was interesting that the court said even if there was a medical malpractice crisis, the law was still violative of the Equal Protection Clause between victims. For example, they give the example of someone that has pain for a month, someone who has pain for a year, and someone who has pain for the rest of their life. And the jury awards $100,000 in example 1, $100,000 in example 2, and $1 million in example 3 for the lifetime. But example 3 gets reduced to $500,000, which the Supreme Court determined to be an arbitrary reduction of the most severely injured and the most severely impacted plaintiff. You know, I used to say this, these caps only hurt the most devastated citizens in Florida. They only apply after a trial, after a jury's awarded damages, after a court has determined that it's substantial or catastrophic in nature. Only that very, very small percentage of people, those are the ones who are going to deny their jury award. That's the most unfair application of caps that you can imagine.
Absolutely agree, and I think the Supreme Court agrees as well. At least 4-3 they agree.
Yeah, it's a close call, wasn't it? It wasn't a given.
Right.
Well, for John and I and our firm, it's a great day. The Supreme Court, in our opinion, got it right. Probably wouldn't be in agreement if I was a medical doctor hearing the news from the Florida Medical Association. But if you have questions about it, give us a call. Look on our webpage, find some written materials that we're going to have out there about how the caps worked and how they no longer work and what's new in Florida in medical malpractice. I'm Marcus Michles. Tune in again next week to our video blog. Thanks for joining me, John.
Thanks, Marcus.